Hello everyone. In this video, we are going to see what is winding up and the different modes of winding up. What do you mean by winding up? Winding up is closing a company. When you start a company, the first step to start a company is getting certificate of incorporation. So once you get a certificate of incorporation, you should commence the business. And the last step of a company is winding up, which means a company comes to an end, that is closing a company. So, what are the procedures to close a company? When a company comes to an end, you have so many creditors, you have lots of debts to pay. So, what is the procedure and what are the other things that you need to do when there is a winding up of company? So, we look into it. Now, yes. So today we are going to understand what is winding up and different modes of winding up. Yes, what is winding up? What we are going to see today, which is an introductory part, what is winding up and role of a liquidator. Who is a liquidator? A liquidator is a person who has been appointed to take care of these winding up process. So when a company is getting wound up, the company should appoint a person or a firm as a liquidator to undergo the process of winding up. Then we are going to see the different modes of winding up and a case study, a real life example, and a small recap. Okay, let's get started. Uh, you can see here understanding the process of company dissolution. So, you please understand the difference between winding up and dissolution. See, winding up is slowly the process is getting done. The company is going to be shut down. Even after winding up, the process will be carried on. That is, calculating the assets, paying the debts. So all these process will be moving on. When the company is dissoluted, when the company comes to the stage of dissolution, then it stops there. Further process cannot be done. So dissolution means the day when the company is getting dissoluted, no more procedure is carried on. But in the process of winding up, you have still more steps to go. Now look into the definition of winding up. Winding up is the process of dissolving a company involving asset liquidation. The winding up may be because of any reason. Company failing to conduct a meeting, statutory meeting, or the company may not have sufficient fund to run the company, or minimum number of members might not be there, or it may face loss. So there may be so many reasons to wind up a company. So because of these reasons, a company is getting winded up. So that is called a company coming to an end. You call it as winding up. And this winding up process is carried on by a particular person who is called a liquidator. So a person called liquidator is appointed to carry on the process of winding up, that is asset liquidation. So the process includes, what does this liquidator do? He will sell off company's assets. For what purpose? To settle the debts and obligations. So this work is done by the liquidator. And also paying off creditors. Creditors are paid from the proceeds of asset sales, ensuring financial responsibilities are met. So when the assets are realized, after paying off the creditors and all things as per the compliance with the Companies Act. So after the procedures, the company is fully shut down. And this process is done by the liquidator, and it is compulsory for the company to appoint a liquidator for the purpose of winding up and distributing it to shareholders. So any remaining assets after debts are paid are distributed among shareholders. And now coming on to the modes of winding up, you have two types, which is voluntary and compulsory. Now first we look into what is the role of liquidator. So winding up is a very big process, and winding up is the last stage of a company and also a very important topic in company law. So first of all, the liquidator is tasked with gathering all assets of the company to ensure proper liquidation, right? When liquidating all the assets, so liquidator is responsible for converting the assets into cash to settle all the debts. So it is the duty of the liquidator to pay off any outstanding debt before distributing any remaining funds. So first, the liquidator's responsibility is to pay off all the debts only if there are remaining amount or remaining fund that will be distributed to the shareholders. So without settling the creditors, you should not distribute, the liquidator should not distribute the fund to the shareholders. And distributing the surplus, as I told you, after settling the debts, the liquidator can distribute the funds, any surplus funds among the shareholders. So ensuring legal compliance. So liquidator should adhere to all legal requirements throughout the winding up process. So throughout the winding up process, there are lots of legal complaints, and liquidator has to strictly adhere to those rules and regulations. And finally, the liquidator prepares a report, detailed report, which is accountable for stakeholders regarding the process. So these are the responsibilities of a liquidator in the winding up process. So next, we are going to see the modes of winding up, a very important topic. What do you mean by modes? Modes means for what purpose the company is being wound up. Why? Because it may be for any reason. So first one is compulsory winding up, and the second one is voluntary winding up. Compulsory winding up, who can do that compulsory winding up? Maybe by the court. So the court can give an order to the company to wind up. Or if the company has become insolvent, so if the company is being stated to be an insolvent company, it comes under compulsory winding up. And what are few more reasons for compulsory winding up? It may be because of by passing special resolution, a company can compulsory wind up with all the permission of shareholders, all the employees. The company can proceed with compulsory winding up, and if it fails to conduct a statutory meeting, see most probably almost after the certificate of incorporation, by 3 to 4 months, a company should conduct a statutory meeting. If not done, that company is put to compulsory winding up. And if there is a failure to commence the business, so once the company is being incorporated, it has to start the business within a year from the date of incorporation. When it goes beyond 12 months, the company has to push up with compulsory winding up. Then reduction, as I told you, reduced members. So you have certain number of minimum number of shareholders in a private and public company. If company is not going to achieve that minimum number of members, so it has to compulsorily wind up. And when a company is unable to pay its debts, it can the creditor can order for a compulsory winding up for their settlement of money. So these are few reasons for compulsory winding up, and it involves various legal proceedings and may result in forced liquidation of assets, and liquidators are appointed by the court, and typically it incurs higher costs due to legal fees and court process. It can have negative implication for stakeholder relationship, and it results in more chaotic asset distribution process. Since it is compulsory winding up and an order given by a court or the creditors, it has a very minimum number of days to sort out everything and to end up the process. I mean, which is to wind up the company. So this is all about compulsory winding up. And even NCLT, you call it as National Company Law Tribunal. It may the compulsory winding up issue order can be given by NCLT also. If NCLT declares that the company should be shut down, then the company has to undergo this compulsory winding up. Not only by the court, the NCLT and NCLAT also can give the order. Now coming to voluntary winding up, what is the reason why the company should voluntarily wind up? Why they have to wind up? Yes, if the company thinks that they cannot proceed further. So with the discussion with the members, shareholders, passing a resolution, the company can wind up voluntarily. If they think that they don't have sufficient fund to run the company, or they are incapable of proceeding further, they can voluntarily wind up the company. And since it is a voluntary winding up, the committee in the meeting itself they decide slowly and proceed further, so it becomes smoother transition as all the stakeholders are involved. So you have sufficient time to realize the asset. The company itself appoint a liquidator. The directors can appoint liquidators, and the liquidators proceed with the further steps to wind up. And it is less costly when compared to compulsory winding up, and it allows for planning and negotiation in winding up process. So it may facilitate an orderly distribution of assets. So as per the circumstances, the company can decide either to go for voluntary winding up or not. If a company really thinks that it cannot proceed further, then it may, with a meeting or with a special resolution, with a meeting with the employees, shareholders, and board of directors, they can go for voluntary winding up. So these are the two modes of winding up, which is compulsory winding up and voluntary winding up. Hope you would have understood what is compulsory winding up and why the company goes for compulsory winding up, and the reason for voluntary winding up. So the next is, as I told you, we'll go with a case study where a successful liquidation process was taken over by Phoenix Company in 2022. It liquidated two firms with a very good demonstration with an effective winding up strategies. They have explained how they have uh, taken the process of winding up. So a thorough valuation process was implemented to guarantee fair market value for the companies sold. So still this Phoenix company is still a creditor's voluntary liquidation process, which is the most common insolvency process, and I have given you a link to have a detailed view of this case study. Now moving on to the final, which is a review part. So let's summarize some of the key points that we have discussed in the previous slide. So, importance of winding up, we have discussed why a company need to wind up, what are the reasons. There may be so many reasons a company getting closed because of so many reasons. So winding up is a very essential for proper dissolution and ensuring legal compliance. Winding up process is a very important one for a company, which is the last stage of a company, and that is being done by a person who is appointed by the court if in case of compulsory winding up, and by the board of directors in case of voluntary winding up, and that person or a firm is called the liquidator, who is responsible for the liquidation of all the assets in an effective way and settles all the debts and uh, distributes the excess surplus fund to the shareholders. Then we have discussed what are the modes of winding up, that is voluntary and compulsory winding up process. We have seen the reasons why there has been a compulsory winding up and why voluntary winding up, and so many procedures we have seen. What are the mm, uh, limitations involved in compulsory winding up, and what are the advantages for a voluntary winding up we have discussed, and the legal frameworks, understanding the laws, which is crucial for this navigating the winding up process. And finally, we have discussed a case study regarding Phoenix Company, how they have provided a best practice, how they have effectively done the winding up process, and they have implemented effective strategies to wind up companies. And that's it. So, hope you have understood the winding up, what is winding up, and responsibilities of a liquidator and the different modes of winding up. Hope this will be helpful for your company law subject. Thank you.